Okay, hello everyone. Once again, this is Jordan Schwartz and Lindsay DeSalvo from ConMa Cary, and we are pleased to present you this final webinar in our 2018 webinar series. And for the final webinar, we decided to do a crossover that relates to both our OSHA and employment law practice. And we've titled it The Intersection of OSHA and the ADA, How Two Labor Laws Align and Diverge. You should see in the chat box on the left I've written some instructions. Hopefully all your lines are muted, so that way we don't hear any feedback. And if you have any questions, it's just easiest for you to type it in the bottom left-hand corner, and we will try to answer those questions either during the presentation or at the end of the presentation. And following the presentation, we will make a recording of the presentation available as well as the slides. You don't feel like you have to write everything down. We will pass on the slides going forward. For those of you who don't know me or Lindsay, we'll give you a brief introduction of ourselves, and we're going to try to keep this webinar to an hour. I think it may be scheduled for an hour and 15 minutes, but I feel like people probably get sick of our nameless, our faceless voices after a while, so we'll try to keep it to an hour, but feel free to ask questions and then we can address them at the end of the hour again. As for me, I do exclusively labor and employment law here at ConMa Cary. And specifically, I defend employers in litigation at both the federal and state level and all the various employment-related statutes. Especially, I do a lot with the Americans with Disabilities Act, and that's one of the reasons I'm talking to you today, because that is the main statute that I'm focusing on. I also do a lot with wage and hour under the FLSA, Title VII, age discrimination, the FMLA, basically everything under the employment law statutes. And I also counsel employers on compliance with all of these laws, and a lot, as I'm sure I'll mention today, with handbooks and policies and procedures relating to hiring, disciplinary action, terminations, and various investigations. I'll now let Lindsay introduce herself, and then we will start with the program.
Good afternoon, everyone. My name is Lindsay DeSalvo, and I'm an associate here at ConMa Cary in both the Labor and Employment and Workplace Safety Practice groups. I also represent employers in litigation and administrative actions, pursuant to all claims, including claims under the ADA, and counsel employers on the same. And then I also represent employers in enforcement actions brought by OSHA, and counsel employers on questions that arrive related to OSHA regulations, including the record-keeping standard.
Okay, thanks, Lindsay. So I'm going to start off the presentation for the first half, just really talking about various issues under the Americans with Disabilities Act. Give you a brief overview, talk about what your requirements are as employers in terms of reasonable accommodations, talk about the application of the ADA to its impact on safety, and then Lindsay, I might also talk a little bit about drug testing if we have time, and then Lindsay will talk about OSHA's e-record-keeping, anti-retaliation provisions, and disability-related record-keeping issues. Hold on. If everyone can make sure to mute their line, that would be awesome, as we are now getting feedback and music is coming on. Okay, thank you very much. I believe the music should now be gone. If anyone continues to hear music, please let me know, but I think we've addressed the issue. Okay, let's start with an overview of the Americans with Disabilities Act that hopefully many of you on this call know. But for now, I just want to give you a brief background because that'll kind of form the framework for the rest of the presentation. So what does the ADA do? It prohibits discrimination against disabled individuals, and specifically, as you guys as private employers, it prohibits you from discriminating against qualified individuals with disabilities in all aspects of the job application procedures, hiring, firing, advancement, compensation, even job training, basically anything that's a term and condition of employment. It also prohibits retaliation on the basis of a disability. To be protected by the ADA, an employee must either have a disability or have a relationship or association with an individual with a disability. And when we get into definitions, a person with a disability under the ADA is defined as someone who has a physical or mental impairment. And I'll describe all that in a little more detail in the next slide or two. But if I just want to point out, if you have a very small company, if you have less than 15 employees, you technically are not covered by the ADA, although it's still a good business practice to really try to abide by the same principles under the law. But keep in mind that if you are such a small employer, while various state statutes may apply, the federal ADA will not apply to you. So in terms of what is or is not a disability, the ADA does not specifically list all impairments that are considered disabilities, which in some way that's a little frustrating for employers because sometimes we don't know what is or is not a disability. But that just is the way it is. So the first thing we need to do typically is at least undertake a quick analysis of whether an individual, let's say he's requesting a reasonable accommodation, whether he or she is disabled. And the definition the ADA does provide is it's a physical or mental impairment that substantially limits a major life activity, such as walking or breathing or working or eating. And it also applies to someone who is perceived by others as having an impairment. It is not intended to cover temporary medical conditions. I've written the quick question here, is pregnancy a disability? Pregnancy is covered under its own set of laws under the Pregnancy Discrimination Act and various state statutes. And someone who's pregnant may be disabled if it's a difficult pregnancy, but for the most part, pregnancy in general is not a disability. I'm going to also refer to the FMLA a few times here. I'm not going to get into the FMLA too much because that's just its own separate presentation. But when I'm talking about disability, it just wouldn't be fair of me to not even mention the FMLA because it's so interrelated. So I just wanted to point out that just because someone is disabled does not mean they're necessarily eligible for FMLA leave. There are two separate requirements and analyses that need to take place. One is a serious health condition and one is a disability. And they are similar, but they're not mutually exclusive. And if you have any specific questions about that, that'll be a question that you have to address with me at a different time. And I see a good question here from someone in the audience who asks, can an employer discriminate if you're the primary caregiver to your child who has a disability? And that's a great question, because as this person picked up on, I said disability discrimination is prohibited against an individual with a disability or someone who is associated with a disability. So yes, I would certainly advise an employee in that situation, or an employer in that situation, to treat the employee as if that employee, at least initially, as if that employee had a disability, and proceed very carefully, because there could be an association type claim that would be associated with that situation. So thank you very much for that question. As I said earlier, initially you need to do at least a quick analysis to determine if the employee is covered under the ADA. But I often get way too many questions where the employer is much too focused on proving that the employee is not disabled. And back when I started practicing in the early 2000s, we were very successful in writing motions to dismiss claims based on the fact that the employee was not disabled. But once the ADA was amended in 2008, it really stopped these types of defenses, and it's just not really a good use of your time anymore to try to argue that, because the courts are so much in favor of finding that an employee at least has some sort of purported disability. So as I say in the second slide here, in the current legal climate, it's just much more productive to focus on how you can make it possible for an employee to work and perform the essential functions of his or her job. For this reason, it is really important that you update your essential job functions in job descriptions. I often review job descriptions from clients, and they're about 10 years old, and they don't contain the current essential functions of the position at all. And that's just not helpful to anyone. It's not helpful to the employee performing the job, and it's not helpful to you if you need to use this as an exhibit to show why the employee cannot perform any essential functions of the job. And I also get a lot of questions about whether you can list mental and physical requirements on job descriptions. And the answer is that you can, but you just want to be careful and try to use words that convey what's actually required instead of conveying words that someone with a disability may be precluded from applying. For example, you might not want to say someone needs to be able to hear, because obviously that would preclude you employing someone who is deaf, but you could say someone who, we need an individual who is able to communicate effectively and exchange accurate information with others. You might not want to say you need someone who can stand or walk, when you could say that the employee needs to move around the office to access office machinery. And there's a lot of other little types of language you can change so that the essential functions of the job are still set out, but that you're not precluding individuals with disabilities from potentially applying to your organization. Another thing I often hear from clients is, well, the employee indicated that he needed some help based on his disability, but he never said he needed a reasonable accommodation. So that means we're not really required to give him one, right? And I tell them that that's not actually the case. You have to assume that the worker likely qualifies as disabled and assume that any request he's making is a request for a reasonable accommodation. And the employee is not, as an employer, you are not permitted to grant a reasonable accommodation that the employee requests or suggests. You are able to come up with a reasonable accommodation that you believe is a proper accommodation based on your expertise and you working with the employee to come up with such an accommodation. But you want to avoid immediately rejecting an employee's request for a reasonable accommodation. You need to at least consider it, even if you think it's unlikely, and then engage in an interactive dialogue with the individual, potentially, with a supervisor, with the HR department, talking to outside counsel, and engage in this dialogue about the reasonable accommodation. Ask for details ask the employee for details on how he believes how he believes his proposal would work in practice. If it's not feasible, try to respond with some sort of alternative that is feasible. Try to get buy-in both from the individual and from the higher-ups at the organization, and make sure to document all discussions. And you can certainly request documentary verification of potential disabilities. As for more about the essential function, as I was discussing, that's very important to have in your job descriptions. One question that I often get is whether attendance at a job is an essential function of a job. And that really depends on the specific nature of the employee's job. And depending on your job, it certainly is possible that as an employer, you may treat regular attendance as an essential job requirement. And if someone has erratic or unreliable attendance and they need to be on the floor at your plant or whatever else it may be, and an individual who can't be there, even if it's because of a disability, they may not be able to perform the essential functions of their job, and thus they may not fall under the ADA. But before you just make that snap judgment, of course, you have to think about and engage in the interactive process and figure out, is there some type of reasonable accommodation that would enable this employee to perform the essential functions of their job. It's really, as this third bullet point is so important. The more communication you have, the better it is. I've advised employers and on occasion employees, and often they're both trying to kind of hide the ball from each other, and that just doesn't help anyone. The more free and open discussions you have, the more you can decide what actually meets your requirements as an employer and what may meet the employee's requirements. As for punctual attendance, the EEOC says that's not an essential function of the job because only job duties can be essential functions. However, I'm not sure I fully agree with that, and at least some courts have disagreed with that. And of course, if an employee is habitually late and he's not able to perform everything he needs to be performing at his job, I certainly think that while, let's say, it's the language for essential function isn't punctuality, but the language is just not being at his job for enough hours or not being able to perform his job while he's at work. I think this is something that shouldn't be taken too literally, but you just need to be aware that the EEOC does take this position before just acting so quickly. These days, given similar to just is attendance an essential function? What about telecommuting? And what I try to counsel my clients is you want to take the telecommuting question with a little bit of a thought about is the employee performing well or not. Often telecommuting is not a great reasonable accommodation to an employee that's already struggling, especially if that employee struggles without structure. But if the telecommuting is, if the employee is performing well and he or she is performing a job function in which telecommuting is a potential possibility, then it certainly may be a reasonable accommodation. Again, just because an employee requests to telecommute doesn't mean you have to allow him to. And there was a famous case about 2 years ago, EEOC versus Ford, where the employee wanted to telecommute, the employer said no, the employee sued, and the employer ended up winning because the employee, who was a resale buyer, it just wasn't feasible for him to telecommute. But again, based on the job, it might be reasonable. So this is just one of those things that has to occur on a individual basis with the interactive dialogue. So another question that also comes up is, what about indefinite leave? And on the one hand, this definitely, the courts have found pretty universally that indefinite leave is not reasonable. So if an employee just provides a doctor's note saying this employee is scheduled to be out for an indefinite amount of time, that is just something as an employer you likely will not have to accommodate. But what happens more often is that an employee says, oh, I'll be back January 1st, and then on December 31st, they send you a note, actually it's January 20th, and then, oh, actually it's February 20th, and it keeps on going. And then at some point, the interactive dialogue has to proceed in terms of any more leave just isn't practical under the law. So just a few best practices. You really want to review any telecommuting and remote work policies for appropriate disclaimers. You want to review job descriptions and include physical attendance as part of an essential job function if that's actually the case. And if you're going to change a rule or how you enforce the rule, it's best if you communicate that in writing and give adequate advance notice. I am now going to move on, so I'm going slowly as normal. I'm going to move on to the direct threat examination. You should all know, hopefully, that ADA does allow medical certifications so long as it's job-related and necessary for business. You don't want to ask for medical certification just to ask for it for curiosity, of course. But if you're determining whether or not the individual has a disability and whether or not he can return to work, it is certainly okay. And just the last thing on that is you don't want to require that for an applicant. You only want to require it after the individual has received a conditional offer and or during employment. Okay, moving on to a little bit more of the intersection between the ADA and OSHA here is something called the direct threat exception to the ADA. So generally, the ADA prohibits an employer from terminating an employee based solely on the history of drug use and addiction. It is not the same if there's current drug use, but based on a history of drug use and addiction, the ADA says you cannot touch that employee. But as an employer, you can take any action and decide to either not hire or fire an employee if he poses a direct threat to the health or safety to themselves or others. Lindsay and I worked on a case a couple years ago where the employee, part of his job description was to be high on buildings, working on scaffoldings. And with his, history of drug use and potential for harming either himself or others, the company took the position that he was a direct threat and that we should not continue to employ him, at least in that current capacity. Often you want to potentially see if there's another capacity you can employ the individual in instead of simply termination, again, if that's a possibility. So under the EEOC, the direct threat means a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by a reasonable accommodation. So you're evaluating this direct threat based on the individual's present ability to safely perform the job. So if he previously had a history of drug use, but still currently that is affecting his current ability to safely perform his job, that is something you need to consider. And the case law has set out 4 factors: the duration of the risk, the nature and severity of the potential harm, the likelihood that the potential harm will occur, and the imminence of the potential harm. And the case law does point out that the harm should be, the potential harm should be serious and even likely to occur, not simply remote or speculative. Often companies don't like that distinction, and they may want to prevent harm that is, even if it is remote or speculative, and I don't necessarily disagree, but under the case law, then it gets a little bit murky. After this, and this is another question we typically get, after an employer conducts and investigates a workplace incident, if it's a direct safety threat or something else, what can the employer tell employees about the incident where a disability is involved? And you need to be very careful here, because the law is clear that as an employer you cannot disclose medical information under the ADA. You really just need to explain to others that as an employer you're acting for legitimate business reasons in compliance with federal law, and potentially you can explain the facts of the situation, but nothing at all with medical information. And of course, penalties, as in many other areas of employment law, if someone sues for discrimination under the ADA, you likely will be on the hook for back pay, compensatory damages. If you lose, certainly attorney's fees, and even punitive damages. So these costs really add up significantly, so you really need to be careful. Make sure that going forward, if you get a request for leave, you communicate with the employee. As I said earlier, open communication is the best. Certainly, you're in your discretion to require medical certifications, either for the ADA or FMLA. One final distinction between the FMLA and ADA that people often get confused about. Again, I haven't talked much about the FMLA, but you might know as an employer that when someone's out on FMLA leave and then they return, you need to place them back into either the same position or an equivalent position with similar pay and similar benefits. Under the ADA, you are required to return the employee to the exact same position. A similar position is actually not sufficient under the ADA. So please remember that. Everyone always gets confused about that, and there are certainly many lawsuits that arise about that. I'm not gonna, in passing, I'm just gonna mention that drug testing is allowed under the ADA because the ADA does not consider drug use to be a disability. However, disability discrimination is an extremely serious risk when deciding whether or not to engage in drug testing, because if an employee is either fired or an applicant is denied because of a positive drug test, and his medication was legally prescribed for a disability, and these days medical marijuana could potentially be a legal prescription depending on state law, the employer can be found liable. So that's all I'm going to say about drug testing for the time being, but that's a specific issue that you really need to address at your various organizations, because it's just such a risk of ADA-related discrimination when dealing with drug testing. And at this point, I am going to turn it over to Lindsay, so she has sufficient time to get into the OSHA components of this presentation.
All right, thank you, Jordan. So first what we'll discuss today in the OSHA context is whether and how drug testing is implicated under the current OSHA regulations. So drug testing actually, and interestingly, is addressed pursuant to OSHA's recent e-record-keeping rule, which was promulgated in May 2016. As many of you probably know, the point of OSHA's e-record-keeping rule was to obtain information on injury and illness records from employers through an electronic submission database. Thus, the main components of the e-record-keeping tool you can see on this page are first, establishments with 250 or more workers would annually submit information from OSHA 300 logs, 301 incident reports, and 300A annual summaries. And then second, establishments with 20 or more workers that fall into certain high-hazard industries would have to annually submit 300A summaries. A quick note on this before we get onto drug testing. As you may also know, so far OSHA has required that all employers covered by the standard, so both establishments with 250 more workers as well as establishments with 20 or more workers in high-hazard industries, only submit their 300A information, but currently the standard still requires both. So the e-record-keeping rule, in addition to this information gathering aspect, also now addresses anti-retaliation related to injury and illness reporting. And the anti-retaliation provisions of the standard actually weren't originally included in the rulemaking, but OSHA was permitted to reopen the rulemaking record for this regulation to respond to the universal complaints that it had received during the rulemaking process that the e-record-keeping rule would lead to underreporting and under-recording of OSHA injury and illnesses that are required to be recorded and reported. As a result, OSHA published a supplemental notice of proposed rulemaking that focused on practices that OSHA perceived would chill employees from reporting injuries and illnesses to their employers so that employers could evaluate and record if necessary. Thus, as of December 1st, 2016, employers were required to inform all of their employees of the right to report workplace injuries, inform employees of the right to report work-related injuries free from discrimination or retaliation, update internal injury reporting policies to remove unreasonable elements, and that second bullet and third bullet are really sort of where the drug testing issues come in. And then finally, OSHA now has the ability under the anti-retaliation provisions of the e-record-keeping rule to enforce retaliation claims against employers without actually having an 11C whistleblower complaint filed by the employee first. So in the context of the anti-retaliation provisions, OSHA made clear that these provisions do not prohibit drug testing, but they use these anti-retaliation provisions and guidance to put some limitations on how drug testing can be used. So in interpreting the anti-retaliation provisions, OSHA has said that these anti-retaliation provisions put limitations on how and when employers can use drug testing. And OSHA did that because it believed that post-injury drug testing could dissuade a reasonable employee from reporting work-related injuries or illnesses because they're concerned, with an invasion of privacy. And also, OSHA also looked at it from the perspective of dissuading employees because post-incident drug testing could be used as discipline or in retaliation for the employee actually reporting the injury or illness. And that was OSHA's perception and OSHA's concern that drug testing could prompt employees not to report injuries or illnesses. Thus, OSHA made clear that drug testing could not be used as a form of discipline, and they focused on the fact that blanket post-injury drug testing policies could have the impact of dissuading employees because there was no real connection between the policy that, say, after every injury that occurs, the employee will be drug tested, as opposed to making it specific to the circumstances of the situation and having some sort of reasonable connection to implementing the drug testing policy. So in an attempt to provide some understanding of the vague anti-retaliation requirements under these anti-retaliation provisions, OSHA did issue a guidance memorandum on October 19, 2016, which addressed, at least in some respect, what OSHA intended by reasonable reporting procedures, including what it intended in limiting discipline related to reports of injury or injuries occurring, post-incident drug testing, and safety incentive programs. In that guidance, OSHA established that post-incident drug testing is permitted where the employer has a reasonable suspicion that drug use could have contributed to the incident causing the employee's injury. It also laid out some factors that the employer should consider and how it chooses to implement its drug testing policy, and in how OSHA itself would evaluate whether drug testing policy was reasonable. However, interestingly, in the wake of OSHA's notice of proposed rulemaking to revise the e-record-keeping standard and the comments that OSHA received when it reopened this record for potential changes, OSHA issued another memorandum in October 2018, which moved the needle slightly in how OSHA interprets its anti-retaliation provisions related to drug testing as well as incentive programs. So the guidance issued in October 2018 repeated much of the same in evaluating the use of drug testing, but it did seem to shift the main question related to reasonable use of drug testing from reasonable suspicion that drug use contributed to the injury that occurred to whether the employer had an investigatory intent in conducting the drug testing. In other words, whether the drug test was given to determine the root cause of the incident. This evaluation would generally be the same because it's still going to be sort of a reasonable consideration. Is drug use a reasonable root cause? And if so, then there is an investigatory intent in conducting a drug test to find that root cause. But it did slightly change the initial interpretation that OSHA put out. So overall, the anti-retaliation provisions of the e-record-keeping rule prohibit drug testing employees for reporting work-related injuries without an objectively reasonable basis. Drug testing can be used as a tool to evaluate the root cause of a workplace injury, but there has to be a reasonable connection to the cause. And on this slide, you can see some of the factors that the employer should consider, again, in putting together a drug testing policy, as well as evaluating the reasonableness of their drug testing policy, and the factors that OSHA will consider if they do have an opportunity to evaluate a drug testing policy and decide whether it is reasonable and doesn't violate the anti-retaliation provisions of the e-record-keeping rule. So the first factor here is whether the drug test was used to evaluate the root cause of a workplace incident that harmed or could have harmed employees. So again, this is a reasonable standard, and it's going to depend on the specific circumstances of the incident that led to the injury. The example that OSHA often refers to is where there's an accident that results in the injury of a forklift driver due to the erratic driving of the forklift at the time of the injury or the accident that led to the injury, then there is a reasonable connection to the cause. Drug use in that case could have caused the employee to be driving erratically, and so there is likely an investigatory intent in there to determine the root cause by using a drug test. Whereas if you have an incident like a bee sting or musculoskeletal disorder, those types of injuries are not going to be something that is reasonable in most cases to believe is somehow connected to drug use. So drug testing in that case wouldn't really be perceived as trying to find the root cause of the injury or illness. The second element is whether other employees who could have contributed to the incident were also tested. Again, going back to the forklift example, if you have another employee who is directing the forklift driver, and there's some possibility that that employee's misdirection could have led to an accident, testing the driver for drug use is important if the accident was caused by an issue with their driving. But in that case, it would also be necessary to test the employee who was directing the driver, because that employee could have also contributed to the cause of this incident that led to an injury, and that OSHA would expect that that person is also drug tested. The third element is whether there's a heightened interest in identifying drug use because of high hazard work. These are going to be more of your safety sensitive positions where it is likely that a mistake by an employee or the impact of drug use on an employee could really have a significant impact on the safety of that employee or of others. And so it's more reasonable in that case to expect that an injury caused by the actions of an employee in one of those positions would be impacted and caused by drug use. And then finally, the last factor is whether the drug test is capable of measuring impairment at the time the injury occurred. So if the drug test that's being given wouldn't actually accurately tell you whether drug or alcohol use was a contributing factor in this instance, then it's not going to be reasonable to use that type of test, and OSHA is going to perceive this as problematic under the anti-retaliation provisions of the standard. This slide just shows the types of drug tests that are not going to be impacted by the anti-retaliations of the e-record-keeping rule. Those first two, random drug testing and drug testing unrelated to the reporting of a work-related injury or illness, will not be affected by OSHA's regulations and OSHA's interpretation of when drug testing can be used, but they could be affected still, as Jordan pointed out, by the ADA. So there would need to be a careful assessment there to ensure that that type of drug testing doesn't run afoul of the ADA. And then to comply with state or federal law, post-incident drug testing will also be permitted when required by workers' compensation. And then finally, what we were just talking about, post-accident when evaluating the root cause of a workplace incident. So again, where there is an investigatory intent and it's reasonable to think that drug use could have been a root cause of the workplace incident that led to the injury. I'll just go through this slide briefly because it doesn't really have as much to do with what we're talking about here. The anti-retaliation provisions of the e-record-keeping rule have also been interpreted to limit how an employer can establish its policy for injury and illness reporting and what they can require in their policy for injury and illness reporting. Particularly, OSHA guidance has focused on the timing of injury reporting as well as the violation of safety rules related to an incident that resulted in injury. As for the timing of reporting, OSHA has generally said that a specific requirement for the timing of a report, like 24 hours, within 24 hours of when an incident or an injury occurs, is not going to be reasonable in the context of the anti-retaliation provisions. You can have a policy that states that injuries must be reported as soon as practicable, because this takes into account the fact that an employee may not immediately know they're injured or may not be able to immediately report that they're injured. And so that's going to be acceptable under these anti-retaliation provisions of the e-record keeping standard. And then in the context of discipline for violating a vague safety rule or for violating a safety rule, OSHA has generally said that violations of vague safety rules related to an injury could be seen as problematic because they could more easily be used as a form of discipline or retaliation for reporting an injury or illness. However, disciplining an employee for violating a specific safety rule is okay under the anti-retaliation provisions as long as the employer is consistent in how it disciplines employees for these types of violations, and employees are not only being disciplined after an injury or illness has occurred. So just a couple quick slides here on the future of the e-record keeping rule, just because this is a rule that is in flux and could be changing sometime in the near future. As I said a little earlier, OSHA did recently promulgate a notice of proposed rulemaking to revise the e-record keeping rule. The main change that OSHA proposed in that notice of proposed rulemaking is that all employers covered by the standard would only have to submit their 300-day annual summaries for all subsequent years in which employers have to submit. Notably, there were no changes to the anti-retaliation provisions of the e-record keeping rule in the notice of proposed rulemaking. Thus, the anti-retaliation provisions will remain in effect as of now, and it doesn't seem like OSHA is intending to change them as of now. That could change. And the guidance that has been issued related to drug testing and policies for reporting of injuries and illnesses will remain in effect related to those anti-retaliation provisions. Comments on the notice of proposed rulemaking were due as of September 28, 2018, so all of those have been submitted, and OSHA is currently undergoing the process of reviewing those comments to come to potentially a final notice or a final rule, or potentially, based on the comments, maybe making additional changes. And then there's also a lawsuit still ongoing that is specifically challenging anti-retaliation provisions. So there could be some impact to the rule based on that lawsuit as well. So what should employers do in the context of this e-record keeping rule to make sure that their policies and procedures are seen as reasonable under the requirements of these anti-retaliation provisions? So first, they should make sure that the e-record keeping policy is not so burdensome as to discourage reporting of injuries. This goes back to what we were talking about regarding the timing of reporting and making sure that the policy considers the fact that employees may not know right away that they've been injured or may not have the opportunity to actually report the injury as soon as required by the policy. Related to drug testing, a drug testing policy that requires blanket drug testing after an incident is problematic, as we discussed earlier in these slides. So employers should make sure that their drug testing policy does incorporate consideration of the specific circumstances of the incident and this concept of whether drug testing is reasonable in those circumstances. And then as a result of OSHA's limitations on drug testing, advised employers that they could consider increasing the use of random drug testing to make sure that they are still, effectively ensuring that employees are not performing their job duties under the use of drugs. But again, if random drug testing is implemented, you need to ensure that it abides by the requirements of the ADA. So outside of the e-record keeping rule, there is another area where disability could be a factor, and that is in the record keeping context. And there are a few different ways that disability could come into effect and impact how the record keeping requirements of OSHA's regulations are implemented. So before I get into the specifics, just sort of a brief overview of OSHA's record keeping rule. As you all likely know, employers are required to record certain types of work-related injuries and illnesses. And this slide here just kind of lays out the different forms that are used for this purpose. The 300 log and 301 incident reports are the two forms that will be filled out immediately, or within 7 days of when an incident occurs. The OSHA Form 300A is the one that's filled out at the end of the calendar year that summarizes the employer's injury and illness data. Just a quick layout of the record-keeping requirements. As I said, injuries and illnesses have to be recorded within 7 calendar days of an incident that results in the injury or illness. If the injury or illness is work-related, is a new case, and meets one or more of either the general recording criteria or the special recording criteria that's provided in OSHA standards. This slide lays out the 5 steps for OSHA record keeping. The first, obtain a report of every workplace injury, and the second, record injuries and illnesses on the 300 log are the areas that we'll focus on mostly in these upcoming slides. And then employers must also complete the Form 301 incident report or first report of injury, prepare and certify the annual summary for the 300A form at the end of the calendar year, and then there is an obligation to retain and maintain records for 5 years, which in the context of the 300 log means updating the 300 log for the entirety of that 5-year period if information related to recorded injuries and illnesses changes over that time. So the first issue specifically that could come into play in the context of a disability is whether an injury or illness is work-related. So generally, an injury or illness is work-related if it's caused, contributed to, or significantly aggravated by an event or exposure in the work environment. And OSHA, in its regulation and interpreting its regulation, has explained that there is a geographic presumption related to injuries and illnesses. And what that geographic presumption means is that it's presumed that an injury or illness is work-related if it results from an event occurring at work. And this includes in the employee's normal work environment or anywhere else an employee may be as a condition of their employment. So if an employee is at a client site when they are injured, if the event occurred at the client site that led to the injury, then that is still going to be presumed to be a work-related injury. And then finally here, there's no eggshell exception, which means that the employer has to take the employee as they are, and this is important in the disability context. For instance, you could have an employee that has a condition that leads to them having brittle bones, and they could trip and fall in the workplace, causing them to break their ankle. And although most employees in that position who experience a similar incident, a similar slip and fall, might have just bruised their ankle or maybe sprained their ankle, this employee, because of their existing condition, breaks their ankle. Because the work environment caused or contributed to that break, that is still going to be work-related, even though the condition that the employee has, potentially a disability, caused it to be more serious than it might otherwise be. There are a few exceptions to the geographic presumption that are important in the disability context. The first is signs or symptoms that surface at work but result solely from a non-work related event. So this is going to be where an employee has a disability and maybe signs or symptoms of that disability arise at work leading to some other injury, but there is nothing in the work environment that at all caused or contributed to the injury. We see this sometimes in the context of an employee who has epilepsy, and they might be in their office when an episode occurs that might cause a seizure. If the employee during the seizure hits their head on their desk and that results in a head wound that needs to be stitched up, in most cases a head wound like that occurs in the work environment would be work-related. However, in that instance where nothing in the work environment caused or contributed to the employee hitting their head, other than the seizure, which is a sign or symptom of their epilepsy, that is not going to be a work-related case because of the fact that nothing in the work environment contributed to it. You could, however, have an instance where an employee's condition maybe causes them to become more easily dehydrated. That sign or symptom could arise at work, but if the employee is performing some strenuous activity at the time that the condition arises and they are injured in the process, that strenuous activity that's required pursuant to their work duties would make the injury or illness work-related, because although they have a condition that contributed to the injury or illness occurring, the work activity, the strenuous activity, also contributed to the injury or illness, and so it would still be considered work-related. As to the second exception, OSHA does not require an employer to treat a mental illness as work-related unless it has been verified as work-related by a healthcare professional who has appropriate training and experience in the treatment of mental illness. An employer is not required to seek out information on a mental illness from the employee for purposes of recordability, and would only have to consider mental illness cases where an employee voluntarily provides the employer the healthcare professional's opinion that it is related to their work environment. This is because OSHA is trying to be sensitive. A lot of times these types of conditions can be something that an employee wants to keep private, doesn't really want other people aware of, and so there are these sort of additional restrictions on when mental illness has to be considered work-related. Where mental illness is work-related, the employee maybe went to the healthcare professional and the healthcare professional determined that high stress in the work environment led to their mental illness or caused and contributed in some way their mental illness. This is considered a privacy case. That's sort of the next main overarching topic that we'll talk about related to disability is this concept of a privacy concern case. So for a privacy concern case, and we'll talk about what those are under the OSHA standard in the next slide, the employer cannot put the employee's name on the OSHA log. In place of the employee's name, the employer should put the word privacy case, and that indicates that the case meets one of the elements that is considered a privacy concern case under the specific regulations. However, OSHA is entitled to that information. OSHA is entitled to know the employee's name related to a specific recordable case. So the employer must maintain a separate confidential list of the case numbers and the employee names that have been included as privacy cases on the 300 log. One other important point to mention here is that in recording a privacy concern case, if there's other information that would be put on the log that would tend to indicate who the person was, even though their name isn't being included, the employer can also use its discretion and evaluate that when it's recording to determine if there's any other information that it should keep confidential and not specifically stay on the log to protect the privacy of the individual. And this slide shows the types of privacy concern cases. So the list is exclusive and limited to those provided here. Anything outside of these instances cannot be considered a privacy case on the 300 log, and employers would otherwise be expected to have all of their employees' names included on the 300 log unless it meets one of these privacy concern cases. You'll notice here that privacy concern cases include mental illness, like we just discussed, as well as HIV infection, hepatitis, or tuberculosis. And then there's one at the bottom here that's a little bit more general, if the employee voluntarily requests to have his or her name not entered on the log. And then the final issue we'll touch on today, related to disability in the record-keeping context, is the outcome of the work-related injury and whether a disability, a work-related disability, the outcome of that disability could result in recordability. So a work-related injury or illness that results in a disability may require an accommodation under the ADA, as Jordan discussed earlier in this presentation. And if an accommodation is required, that could actually make an injury or illness recordable depending on the specific type of accommodation. Specifically, work restrictions and job transfers are an outcome that is recordable under the record-keeping regulations, as well as days away from work. So if a work-related disability requires that an employee be restricted from lifting a certain amount of weight, that could be considered a work restriction that would make the injury or illness or the disability recordable if that is restricting one or more routine functions of the employee. Additionally, if the injury or illness requires an administrative leave for surgery or to recover from surgery, that can also be considered a day away from work situation, or that would be a day away from work situation, and that could lead the injury or illness to be recordable if it meets the other elements of a recordable injury. Last note here, there are OSHA regulations that could limit what the employer can do in the realm of accommodations. For instance, if an employee is medically unable to wear a respirator and the employer is considering transferring them to a position as an accommodation for another disability, but that position requires use of a respirator under OSHA regulations, the employer wouldn't be able to make that transfer, and so they would have to consider some other accommodation under the ADA that they could give the employee. And this last slide here, I'm not going to really spend any time on, but it just sort of summarizes what's required at the end of a calendar year and summarizing the record-keeping information from that calendar year. And then also, again, the requirement that records have to be maintained for 5 years and 300 logs have to be updated as information changes. So if for instance, a work-related disability didn't initially lead to the need for surgery, but a year later surgery is required and that results in days away, then the employer would be expected to go back to the 300 log and make that change in the 300 log. All right, we will take a look now and see if we have any questions that we can answer.
Okay, I'm going to scroll back up and look at some of the questions from my portion of the presentation, and then we'll see if there's any from Lindsay's. The first one I see is when you take a look at pregnancy and disability, should this vary by state when looking at accommodations? You always want to check state law because there could be some requirements under your state law that's different than the PDA or the ADA. But for the most part, the accommodation that you come up with should be a reasonable accommodation under the situation, and it probably wouldn't vary by state. Although if you have operations in different states and there's different accommodations that work in one than a different state, then it might. But for the most part, I think when looking at accommodations, there's either some that are reasonable or not reasonable based on your business operations, and probably wouldn't vary too much by state. but you need to check to make sure. The next question is, if an employee provides a note to be off of work for 2 days with no sick leave available and released to come back on the 3rd day, it would appear that this is a temporary disability. And yeah, that's correct. Certainly, if you're off for 2 days, it would be, you know, very difficult for an employee to say that's a impairment that substantially limits a major life activity. So that employee probably would not be covered under the ADA. It's possible maybe they would be under FMLA if there's a serious health condition, but certainly not under the ADA, and probably not even under the FMLA for just 2 days. Next one, is a business required to engage in an interactive discussion with an employee who is approved for long-term disability with no expected return to work date? I would always recommend that you engage in an interactive discussion. At the end of the day, you likely, in this situation, you may not be able to find a solution, and then you have as a defense that you engage in the interactive process and you could not find a solution that qualified as a reasonable accommodation. But sometimes you can be sued just for failing to engage in an interactive discussion, even though you likely would have been off the hook at the end of the day. So it would be a little bit short-sighted to just say, oh, you're not even going to qualify, so we're not even going to engage in a discussion. That will almost never be the answer. Let's see. If an employee that is not FMLA eligible in California under state or federal law has requested time off for surgery, how much inquiry should an employer undertake to determine if there is a possible ADA issue? I mean, you need to find out what the issue is, because just because someone isn't qualified for FMLA, that has absolutely no bearing on whether or not they're qualified for the ADA. Sometimes the FMLA, you might have already granted 12 weeks, but then the employee will be qualified under the ADA, or maybe the employee is a new employee who is not eligible under the FMLA, but that employee may be eligible under the ADA. So you need to ask for medical documentation and or find out what the issue is to determine if a reasonable accommodation should be granted under the ADA. The next one, an employee will not provide information about a condition other than demanding full-time telework for PTSD. The employer believes it is an essential function to be in the office part of the time. The employer requests guidance from its own medical expert. The medical expert wants more information about the condition. Since the employer will not provide information about the condition, should the employer contact the employer's provider or just say that the employee has failed to engage? That's kind of a long hypothetical that we might need more information to give too much advice, but I wouldn't contact the employee's provider without going through the employee. If you ask the employee for more information and he refuses to give it to you, then there's nothing you can do. You're attempting to engage in the interactive process and he is not letting you. But to kind of potentially go behind the employee's back to get more information is not a good idea, and that itself could be violative of the ADA for getting medical information you may not be entitled to. Just a couple more, it looks like. The issue of medical confidentiality comes up frequently between our safety personnel and HR/ADA personnel. Oh wow, there's a lot more. Oh wait, where did that go? The issue of medical confidentiality comes up. I mean, I may have mentioned that. The best practice is the HR person needs to share as little as possible with anyone else in the organization, but you need to make sure that safety is the primary concern. So really the best practice is as little as possible to ensure that the employee is not endangering himself or herself or others. And again, that might be something that we might need more information on.
All right, so I think we'll just do a couple more questions, then we'll have to hop off. And if people want to contact us, our contact information is available, and we'll be sending these slides to you. So you can contact us if we aren't able to get to your question. But a couple more here. I think this is in relation to the anti-retaliation provisions of the e-record-keeping rule. What does this discipline actually mean in this instance? There's no specific definition, surprisingly, provided by OSHA as to what discipline means in this context. It's probably going to be similar to the usual types of discipline we see. So, you know, a suspension or a write-up or a termination. Those are all going to be different forms of discipline that might come into play in the context of your injury and illness reporting rule or in the context of drug testing. And another question here, if an employee is involved with a workplace incident, we drug test. If he or she is positive, we terminate. Are we in violation of the law? This could potentially be in violation of the law if the reasonableness of the drug testing isn't really considered pursuant to the implementation of the policy. So again, OSHA's big concern here is going to be whether there was whether it was reasonable to believe that the root cause of an incident could be drug use, or that drug use could have been a root cause of what caused an incident that led to an injury. So again, in those instances where drug use, even if an employee maybe did use drugs, there could have been no way it could impact the situation and cause the injury or illness, then OSHA's likely not going to see that as reasonable. But, you know, I think it can be pretty broad. I mean, if there is some basis to believe that drug use could be a root cause, then drug testing would be reasonable in that situation. I do think that a lot of times if OSHA is evaluating a drug testing policy, and we haven't seen them do this very often, but if they are evaluating drug testing policy, it's going to be kind of taking a look at the policy and evaluating kind of just based on their reading of the policy. So if the policy itself seems overbroad, that could be problematic, and OSHA may choose not to dig much deeper and take action based on that. So I do think that an employer with sort of a blanket drug testing policy should evaluate and see if there's a way to maybe update the policy to bring in that concept of, you know, drug use being a cause of the incident. And then another question here, and this will probably be the last one that we have time for today, is it considered reasonable if driving forklift and they just knock equipment over but no other suspicions are apparent? So in the case where an employee maybe is driving a forklift or another powered industrial truck or vehicle, and while they're driving knocks over the equipment in the area, would that be sufficient to say that there is a basis to drug test in that instance? I think if you are drug testing the driver in that instance, then it would be reasonable to do so. In circumstances like that, the driving often seems the most likely cause of the incident, and so drug testing the driver is reasonable, particularly where, you know, their drug use could actually impact how they drive a vehicle. So I think in that case, it would be reasonable to drug test the driver.
Okay, and that's all we have time for today. On this last page here, we have our contact information. Feel free to contact us with any further questions, and we look forward to presenting to you next year in our 2019 webinar series. Thank you all very much.